please the court. Good morning, Kevin Brennan on behalf of Merrill Smith, Zara Brennan, and Olney. For the former wife and appellant, in this case, Carol Kennedy, in dealing with the brief, there were 9 issues that were briefed, and the brief is sort of difficult to understand as 3 of the issues weren't really preserved on appeal, and several of the issues are dealt with in multiple parts of the brief. So the easiest way for me to do it is to just go through it one by one, and obviously I'll skip through the ones that aren't very important and try to focus on the ones that may be the bigger issues. The biggest issue from our perspective, and this is relevant as it relates to the credibility of the former husband, and also some of the things that the trial judge had to deal with in terms of making the decisions, which was his non-compliance with virtually every order that was entered. We had to attend 23 hearings in this case, emergency hearings. 14 or 15 orders were entered against the husband. He was held in contempt 5 times and warned he would go to jail on 3 occasions. He requested 8 or 9 continuances, never filed a financial affidavit even disclosing the business as an asset, which was the biggest asset in the case. He, to date, has been through 6 different lawyers, and this is now the 5th year that the case has been pending. The trial judge, he was an excellent trial judge. He took the time and even probably allowed in some evidence from the former husband's perspective that maybe should have been disregarded, but listened to all the facts and made the correct decisions. The first issue was the appellant contended that there was insufficient findings of fact to support the equitable distribution. I've cited in my brief that there was 8 pages of specific findings supporting the equitable distribution. The court had equitably distributed all of the assets and liabilities with the exception of the 07 and 08 tax liability, which it spent an entire page on describing in and of itself. The rationale for the court's distribution was simple. It was that given his noncompliance...
Maybe I can spare you some difficulty. I assure you we've read your briefs in detail. We've read all the attachments. We've read the order. I would suggest maybe focusing us on something specific that you think is in controversy or that's a close call, and
okay.
You really don't have to read all of the issues to us.
Yes, Your Honor.
Okay.
Thank you. I think the only 2 issues that I'll probably address then are the tax issue and the imputation of income issue, since those were the 2 issues that the trial judge was most concerned about.
Okay.
With regards to the tax issues, the tax liability or alleged tax liability for 07 and 08 was unequally distributed to the husband, and there was a number of reasons for that. Again, this was, and I know you guys hear this every day, but this is, again, an abuse of discretion standard, and the Kanakaris case says if no other, discretion is only abused where no other reasonable person would make the same decision. And in this instance, he was ordered to file his tax returns from the very beginning of the case. He was ordered in September 8th of 2010 to file his tax returns. He didn't do it. He was ordered several more times to do it and never did it, held in contempt for not doing it, and actually came to the court and requested a continuance with, I think, his 4th lawyer at the time. And we agreed to a continuance based on the condition that he would file his tax returns so that we could have that information. Even with that, he still never filed his tax returns. Now, his forensic accountant even testified that he needed to file his tax returns, contest the disputed alleged IRS tax debt, because it was wholly contingent upon him filing those returns, and without filing those returns, our accountant testified there's no way that you could ever put a value on it. Now, some of the interesting facts there were that the tax liability, he testified, allegedly came from a settlement that he received where he was paid out 05, 06, 07, and 08. Well, he had the same income streams in 05 and 06 and didn't have tax liability for those years. So reason to believe that he wouldn't have a tax liability for 07 and 08. So essentially what he was trying to do was create a situation where he could get credit for the alleged IRS tax debt, file his returns afterwards, and wipe out his debt and shortchange the wife on equitable distribution. And the Supporta and Ugarte cases out of the 3rd District talk specifically about not creating a situation or not being allowed to create a situation which shortchanges your spouse in equitable distribution. So that was the basis upon which the trial court held, and as I've cited in my brief as well, another option that they went with the unequal distribution, but another basis that they could have gone through was that it was speculative. In the Lorman case, which is out of this court actually in 1994, it stated that if a debt is too speculative, that it shouldn't be distributed. But if it's a substantial debt, or if there's substantial findings that it actually is a debt, it could be unequally distributed. So under either basis, we believe that the court made the correct decision. The other issues were alimony, and I won't go through all the alimony factors because there's 5 pages or so of specific findings in the judgment. But the only other issue was dealing with imputation of income, and they sought to impute income to the former wife for purposes of determining her income and alimony.
The income that was used was consistent with her earnings history?
It was actually slightly higher. So what had happened is she had worked the same job for 30 years. She had worked the same hours for 20 years, which was the entire course of the marriage, where she had worked. She's a flight attendant, so they have flight hours, not actually work hours. And so she had worked, I think, somewhere between 40 and 50, 45 flight hours, and she had averaged an income of about 20 to 22,000. Now,
they used 30,000 and change for the computation, correct?
And that's correct, Your Honor. The reason for that was while she was away at work, her husband had moved all of her stuff out of the house and moved in the girlfriend, and so she actually went into a rental property and had to work more hours until we could get back to court to get some temporary relief. So she had to work more hours in 2011 and made $30,000 plus, and so that's the figure that we used for her, even though she wasn't on track in 2012 to earn that same amount. And I've given you the reasons for that, as her health was declining and she had been diagnosed with arthritis and was on medications.
Was there any evidence presented by the other side that she was voluntarily underemployed?
Well, that was the argument. The argument was that she was voluntarily underemployed. However, and I'd like to point to the suit case, which is out of this district. Just about 3 years ago, Judge Alton Byrne issued the opinion where, or authored the opinion rather, where in that case the wife she was in her mid-50s, and during the course of the marriage she operated these 2 businesses and maybe didn't work full-time 40, 50 hours a week, but worked the same consistent schedule throughout the marriage and had made a modest income. And in that case, they said, she was working, she was doing what you were doing during the marriage, so that was sufficient. And in our case, I think the facts are even more significant, where she had literally done the same job for 30 years, worked the same hours, and the income that was used was actually higher than what she had done during the marriage. So I believe the facts in our case are even more significant than the suit case. So with that, we believe that income should not be imputed because the court had already used her highest income that she had earned in certainly the most recent years. And
unless the panel has any questions, I think we have a good hand.
Thank you very much. Yeah.
Very good. Thank you. The next case is Houston versus Walter.